Hi, everyone. Thank you all for being here in this session of the Oxford Jurisprudence Discussion Group. We are delighted to host Professor David Dyzenhaus. You all know him. He's a university professor of law and philosophy at the University of Toronto. Um, and today he'll be presenting the legal experience of injustice. And he wants to talk for around 30 minutes or so, and then we'll open it up to the usual Q&A. Professor Dyson thank you very much for being with us today. The floor is yours.
Well, thank you, and thank you very much for coming to this session. I was thinking before the session that I've crossed the threshold of this college many times. I did my DPhil here, but every other time before today was to meet my supervisor or supervisors. So I worked mostly with Ronald Dawkin, but also with John Finnis, because Dawkin was away half the year. And I still have this feeling of fear when I cross the threshold of university college. In fact, I had my probationary MLit exam. I don't know whether you still call it that here, at the end of the first year. So this exam where you have to hand in a paper, two people grill you who are not on your supervisor. And that was not the happiest day of my life. But today I'm hoping will be more productive. I finished this DPhil in 1988, and I am, and this is entirely sincere, still trying to get the argument right. And the last attempt, Javier kindly brought this along, is this book, The Long Arc of Legality, Hobbes, Kelsen, Hart, which I published early last year. And in this book, I make an attempt to get past the standard debate in philosophy of law, that is, as I understand it, the legal positivism and its critics debate. And I try to do this by showing that both sides are really attempting to understand the idea of legality and the idea of legality in the modern legal state, and how that idea, or how legality in particular, mediates the relationship between ruler and ruled, between sovereign and subject. And the puzzle I explore in this book is what I call the puzzle of authority, of legal authority, that law seems to be both a matter of might and right. And that paper is explored in this paper, and that idea is explored in this paper today and also elsewhere through Hobbes, which is why Hobbes figures as the first person in my subtitle. And one of the ideas that I find fascinating in Hobbes is his metaphor for the law, that we should understand the law as a chain which is fastened by legal subjects to the lips of their sovereign. And the idea of law as a chain, this metaphor, crops up all over the place in political philosophy and in legal theory. One finds it in Rousseau in the first lines of the social contract. One finds it in Kelsen, who talks about a chain of authority. One finds it, of course, also in Fuller, who talks about a bond of reciprocity. And here my claim is that Hobbes's artificial chain of the law is more or less equivalent to Fuller's bond of reciprocity, and that Fuller, like Hobbes, imports into his understanding of the structure of legal order what Fuller was much later to call the inner morality of law. Hart was, HLA Hart, needless to say, was, of course, aware of this metaphor. And at a certain point in the concept of law, he talks about the idea of law as a chain, and says this is a troubling idea because it seems to suggest that all there is to law is compulsion, but there's more to law than compulsion. There's also the idea of authority. When Hobbes says that legal subjects fasten the chain of the law to the lips of their sovereign, there is something troubling about this image, because it supposes, as Hobbes indeed supposes, that subjects consent to being enchained. And Hart was aware of this danger in moving from the idea of law as compulsion to law as authority. And he tried to, in a way, defuse this idea or disarm this idea by talking about authority in two particular ways. First, when Hart thinks of the authority of law, he's fairly clear that it's not moral or legitimate authority, as John Gardner later coined the phrase. For Hart, the normativity of law is normatively inert. And recently, an American philosopher of law has started to talk about the weightless normativity of law. So Hart thinks it's important to get away from the image of law as the gunman situation writ large, move to understanding law in the register of authority, but he has a very particular understanding of authority as weightless or normatively inert. And that, in his view, I think allows him to remove the troubling aspect that he finds in Hobbes and others of consent to authority and consent to legitimate authority. There's a second way in which Hart diffuses or disarms this idea of authority, and that is, as people here will surely know, that for Hart it's an existence condition of legal order that only the officials need accept the authority of the legal order, regard the legal order as in some sense rightful. The subjects don't have to accept the authority for a legal order to exist. All they have to do is obey. In essays on Bentham, Hart confesses, and this is in response to Joseph Raz, that his account of authority is unsatisfactory. Raz put forward the idea that when officials make decisions in the register of authority that affect the interests of subjects, they must ally themselves with law's claim to legitimacy. And Hart, I think, was troubled by this argument of Raz's, both because it brought in the idea of legitimacy and because it imported subjects into the existence conditions of the authority of a legal order. But as he said, although he wanted to stick with his idea of normatively inert authority or weightless authority, he thought this idea was deeply paradoxical, maybe even confused. And what I'm interested in this book and also in this paper is the extent to which one can trace in Hart as well the idea of a bond of the sort that Hobbes put in place when he thought that there was a reciprocal relationship that the law helped to establish between sovereign and subject, and that Fuller also thought existed when one had a properly functioning legal order. That is, there would be a reciprocal relationship between sovereign and subject, such that when the law addressed subjects, the law would address subjects in a way that respected their dignity as responsible agents. And the paper for today builds on this set of ideas. And I also try to build a bridge from the book in this paper to another book, this time focused on themes from chapter 5 of the book, which is called The Politics of Legal Space. And the idea in this chapter, and the main idea of this paper, is that in the legal order of a modern legal state, law will provide, just because there's a legal order there, law will provide the resources that make what I call human rights lawyering possible, even when those who have power to make law use that power to oppress and to discriminate. If the power is used in that way, it will be the case that tensions will arise, legal tensions in the legal order, because of the presence of the resources that legal order enables. And it's these tensions and these resources that, or so I claim, human rights lawyers can exploit. A further claim in the book and also in this paper is that the resources that are available to human rights lawyers if a legal order is in existence can be removed only by shifting the legal order from one type of legal order to another, or by stripping it of the qualities that make it a legal order. That is, by turning it into an order which is an order of legally unmediated power, or an order, as one might put it, of prerogative power or discretionary power. As you will have seen, the paper starts with some quotations from Judith Sklar, and that's because it was written for a workshop at Sydney University where the first quotation was made the theme of the workshop. So just to go over these quotations quickly, as I point out at the beginning of the paper, Sklar, in The Faces of Injustice, criticizes what she calls the normal model of justice, which views injustice as a prelude to or a rejection and breakdown of justice, as if injustice were a surprising abnormality. And the central insight of the book is that the real realm of injustice does not stand outside of the gates of even the best of known states. Most injustices occur continuously within the framework of an established polity with an operative system of law in normal times. And I think that insight is completely right. And she adds a second insight, which I regard as a Hobbesian insight. She doesn't term it that. She says that without juridical institutions and the beliefs that support them, there can be no decent, just, or stable social relations, but only anxiety, mutual mistrust, and insecurity. And what I try to show in the paper is how, if we explore the second insight, the insight which I call the Hobbesian insight, and we inquire into what happens when juridical institutions are used to create indecent, unjust, and unstable conditions, we will understand better what I call the legal experience of injustice, the peculiarly legal experience of injustice when that injustice is perpetrated by law. So in section 1 of this paper, I work with Sklar's claim that Fuller's inner morality of law is compatible with, as she puts it, governments of the most repressive and irrational sort. And she cites in support of this claim Nazi Germany and also pre-Civil War US, in particular the slavery provisions of the US Constitution. It's quite clear if one reads Sklar's work on legalism and companion essays that her target in making this claim wasn't just Fuller. She regarded this claim about legality being compatible with injustice of a highly repressive and irrational sort as aimed more generally at legalism, and she understood Hart and legal positivists, as well as Fuller, as putting forward a legalistic view of the world, and not really understanding how that view of the world was compatible with great injustice. What I try to show as I move through this section is that if one spends some time on the study she refers to of the Nazi legal order, that is Ernst Frankel's book, The Dual State, the lesson that we learn from Frankel is rather different from the lesson that Sklar took from Frankel, and that is that the irrationality and repressive nature of Nazism was fully compatible with legality, particularly legality as Fuller understood it. Because, as Frankel explained, if one wanted to understand the Nazi state, one had to understand it as two states side by side. The one state he called the normative state, which was what was left over from the pre-Weimar period. The other side was the prerogative state. In the prerogative state, it was the case that the officials of the Nazi party could do as they wanted in order to further the interests of the party. And further, they were able to take any matter out of the normative state and deal with it in the prerogative state, either by wrenching the matter away from some institution in the normative state, or once, say, a judge within the normative state had made a decision, just overruling that decision. And so Frankel concludes in his book that there was no rule of law in Nazi Germany. Indeed, he concludes that there was no legal order in Nazi Germany. And I think one can drive his claim further and say that if we accept with Dworkin that legal rights are those rights that we can demand from our adjudicative institutions, there were no legal rights in Nazi Germany, at least at a certain point. And what this shows, I think, contrary to Sklar, is that the dual state that Frankel diagnosed in the Nazi political order is completely incompatible with any understanding of legality, let alone Fuller's. I suggest further in this part of the paper that if one looks more closely at the situation that Sklar mentions when talking about the pre-Civil War USA, and that is the situation of slaves, that matters were a lot more legally complicated than Sklar thought. That is, the attempt to legalize slavery in a kind of half-hearted way through the Constitution and then through state law created all sorts of legal tensions within the legal order of pre-Civil War US. These tensions came to a head in particular with the problem of fugitive slaves, that is, slaves who managed to escape from southern states to northern states where slavery had been abolished. And then the question was whether these enslaved persons or formerly enslaved persons would be rendered back to the condition of slavery, which was supposed to happen under the Fugitive Slave Acts enacted by Congress. And those tensions were tensions which the human rights lawyers of the day could work with in trying to represent these enslaved persons before northern courts. The tensions could not be resolved legally. Indeed, they could only be resolved to the extent that they've ever been resolved by the Civil War. But the fact that there were these legal tensions in trying to perpetuate the situation of legally imposed slavery, I think shows that the situation of pre-Civil War US was a lot more complex legally than Sklar supposed. And what it shows is that there is a sense in which slavery is incompatible with legality, not compatible, as Sklar claimed. The importance of the dual state to my argument is that I think what the dual state shows us is that if we think of different legal states as being placed on what I call in the paper, also in the book, on a continuum of legality, so some states will be more compliant with the rule of law than others. We can put an ideal rule of law state at one end, and then as we journey towards the other end, we get states that are less rule of law compliant until the point where a state falls altogether off the continuum of legality, and I take the dual state to mark that end. The dual state is not on the continuum of legality. Why? Because there was no rule of law in Nazi Germany. And so what I do in the next part of the paper is to explore two other, what I call ideal types of legal state that are on the continuum of legality, but that manage their discrimination and oppression of some of the population in rather different ways. And the first state I deal with is the state which has been my career-long object of study, including in my DPhil here, and that's the state into which I was born, the apartheid state. And the apartheid state I take to be a perverse variant of a rule of law state, in that there was throughout the apartheid period a commitment on the part of the governments to the rule of law. And the way that that commitment was realized is that all subjects of the apartheid state were subject to the same general norms. So they were subject to the same, if you like, constitutional norms of the legal order. What apartheid law did was it carved out vast exceptions to those general norms in order to place the black majority of South African legal subjects in pockets of discrimination. So the black majority lived to some extent in a different world from the white minority, but not an altogether different world, because to some extent the black majority was subject to the same constitutional norms as the white minority. That created the category of what I call in the paper second-class citizens, and it created tensions in the way that law governed the black majority, and it was these tensions that human rights lawyers were able to exploit throughout the apartheid period. They were able to rely on the legal resources that came from the constitutional norms to contest the implementation of apartheid law through the statutes that put in place the policy of apartheid. The second kind of legal order that I explore in this section is the legal order of what I call the parallel state. And here my example is Israel and the occupied territories. And what one has in Israel and the occupied territories, although what I'm about to describe is now under severe stress because of the legislation planned by the Netanyahu cabinet, what one has in this parallel legal order is two separate legal spaces, and there's different constitutional norms operate in each of these spaces. And the constitutional norms from the space of Israel are not supposed to reach into the space of the occupied territories, because the occupied territories are supposed to be governed under belligerent occupation by the norms of international law and also by the local law that existed before occupation, and also according to the demands of security when it comes to managing the occupation. So here one gets an attempt to have two different populations in one overarching legal framework, but with two spaces separated to the extent possible, so as to stop norms seeping from one space to another. But what I explore in the paper to some extent, and at more length in the book, is how it's very difficult to stop the norms from traveling in both directions. And what I think one can see, if one puts the dual state together with the apartheid state and the parallel state in one paper, as I've tried to do here, is something like the following. That if in an operative legal system, as Sklar calls it, or a legal order, I take these terms to be synonymous, those who wield legal power wish to escape the reach of legality, they have two options. They can either change the nature of the legal order, so change it from an apartheid state into a parallel state, or vice versa, in order to prevent the constitutional norms of the legal order from applying to all those who are subject to law. Or they can change the order altogether, turn it from being a legal order into an order of legally unmediated power, in which case they create a dual state. If they don't exercise that last option, then it will be the case that, however meager, there will exist legal resources in the legal order that permit human rights lawyers to contest the oppressive law that is enacted in that order. And what this shows, or so I suggest, that there are certain kinds of ideology that legal order is inherently resistant to. There are certain kinds of political ideology that can't be fully implemented through law. The example of the apartheid state is supposed to show that apartheid ideology could not be fully implemented by law. The example of the parallel state is supposed to show that the kinds of ideology that are in contest in Israel also are resisted by the commitment to governing through law, by the attempt to implement whatever ideology people wish to implement while maintaining a commitment to the rule of law. And what unites the kinds of ideology which legal order is inherently resistant to is, I think, that the ideologies seek to diminish the equal standing of legal subjects before the law. There is a way of diminishing the equal standing of subjects before the law without turning the order into either an apartheid state or a parallel state, and that is to remove the standing of subjects altogether, which is what slavery attempts to do, that is turning people into objects. But I think it's interesting, not something that I dwell on in the paper, to examine historical examples of legal enslavement, because it turns out that it's very difficult to relentlessly consign human beings to the condition of slavery. And as long as human beings aren't totally consigned to the condition of slavery, tensions will exist in the legal order, that is, legal tensions, through the way that in which enslaved persons are a kind of second-class citizen. To some extent, they have some standing before the law. And what this further might show is that where there is the rule of law, or put less in a less value-laden way perhaps, where there is legal order, law will enable some measure of freedom and dignity. And it's that measure of freedom and dignity that I think makes human rights lawyering possible in any legal order, just because it's a legal order. This doesn't tell us that one should be a human rights lawyer, because human rights lawyering is always a fraught and morally complex business, and the rest of the paper tries to explore the ways in which human rights lawyering is always fraught and morally complex business, and from there build a connection to this set of reflections on different ideal types of state to political and legal theory. So the next section of the paper starts with a set of reflections by a human rights lawyer who works in the occupied territories, Michael Sward, from the last chapter of his really wonderful book on human rights lawyering in the occupied territories, and also deals with a debate that occurred in South Africa in the 1980s between two academics about whether the few liberal judges on the apartheid bench should resign because their presence on the bench was contributing to the legitimacy of the apartheid government. And Sward, in his book, is deeply troubled by what he sees as the complicity of human rights lawyers in the very injustice that they seek through their human rights lawyering to combat. He tells us right at the beginning of this chapter that human rights lawyers practicing in court can never bring about regime change. And what's more, through their participation in the legal order, whether through their victories or through their losses, their activity serves to legitimize the very injustice against which they're struggling. Why does this happen? It happens, Sward suggests, because of certain characteristics that he associates with the rule of law, but also he says it happens because legal norms do, as he says, justify. And in participating in the production of legal norms through their human rights work, human rights lawyers are contributing to the justificatory work that legal norms do, and hence to the legitimacy of the legal order against which they struggle. Now Sward claims in this chapter that he can make this suggestion about legal norms that they do justify. It's just in the nature, one might say, of legal norms that they justify, while, as he puts it, sidestepping, I think, the fervent debates in philosophy of law about between legal positivists and their critics. And in the remainder of this part of the paper, I say that there is something to Sward's suggestion that he can sidestep these debates. Why? Because it is the case that if we look at things from a positivist perspective, mainly HLA Hart's perspective, Hart, I think, can admit that legal norms justify in the way that Sward suggests. And I think he would be unsurprised by Sward's claim that the work that human rights lawyers do does serve to legitimize the regime in which they operate. And he can take all of this on board because of the move that he makes in his legal theory that I sketched right at the beginning, which is that he says that the authority of law is a normatively inert authority or a weightless authority. So it might be the case that from the perspective of participants in the legal order, that through taking what Hart calls the internal point of view, they commit to the authority of the legal order, they regard the legal norms of that order as doing justificatory work, and this may serve to legitimize the regime. But Hart supposes that he can defang that idea by telling us, well, all that might be true, but yet when we understand the authority of law, we can see that this is not genuine authority. It's not genuine, at least in the sense that it's not moral authority or legitimate authority. And so one should think that the work that these human rights lawyers are doing and does not really justify anything. It's just a game that one has to play if one's going to participate in legal order. And here I suppose that Raz is right, that it is the case that if one participates in legal order in this way, that one is shoring up the legal order's claim to legitimate authority, and that can't be understood unless one brings legal subjects into the picture in a way that Hart tried to avoid doing by saying that only officials need accept the authority of their legal order. And bringing legal subjects in takes me to the very last section of the paper, which is the section on what I call the political sociology of obedience. And in bringing in the political sociology of obedience, I'm trying quite deliberately to resurrect for legal theory Austin's idea of the habit of obedience, because I think the habit of obedience is actually given a much more sophisticated treatment in Austin than Hart conveyed. And in seeing why the habit of obedience is, as Hart admitted, an existence condition of legal order, but why it's not an unreflective habit as Hart understood it, perhaps motivated by coercion, but a habit which involves some stance of acceptance on the part of subjects, that one can see why it is the case that there is a political sociology to legal order that involves the subjects accepting the legitimacy of law, and that legitimacy is conditional on there being the resources available to human rights lawyers that will enable them to try to persuade courts to give a satisfactory answer to legal subjects when they challenge the law and ask why it is the case that the law dictates certain results for them. And the last suggestion that I'll make today, and that comes towards the end of the paper, is that this habit of obedience will be maintained only if it's the case that a legal order persists in being a legal order. If a legal order persists in being a legal order, it will be the case that the resources will be provided to human rights lawyers that will enable them to try to persuade judicial and other institutions to provide satisfactory answers to legal subjects who challenge the law when the law seems to discriminate against them or to oppress them. The only way, as I've suggested, for a legal order to avoid this potential for human rights lawyering to take place is to change into an order of unmediated prerogative power. That is to change from being a legal order into something like a dual state. And that at least tells us that there is the potential for the argument that Fuller tried to make, that there will be an inner morality of law as long as there exists a legal order. It doesn't tell us much more, but at least gets us onto the path of seeing why there was more to Fuller than generally both legal positivists and, for that matter, Ronald Dworkin supposed, because people don't often recollect is that when Fuller published his book, The Morality of Law, which was subjected to withering criticism by Hart and others, Dworkin fully joined in that criticism. So this is an attempt, as I mentioned in a footnote, to show that Fuller's Inner Morality of Law has a lot more going to it if we look at the way that legal tensions arise in legal orders when law is used to impose either oppression or injustice on those subject to law. And I think I've probably gone over my half an hour, so I'll stop there.